All right, well, good morning, everyone. Thank you for joining us here. Rob Bonta, California Attorney General. And before I begin, allow me the privilege to thank and introduce members of my team who helped get us to this point. Rachel Foodman, Deputy Attorney General, Tim Lundgren, Deputy Attorney General, Daniel Osborne, Deputy Attorney General, Michael Elisafin, Supervising Deputy Attorney General, Nick Akers, Senior Assistant Attorney General, and Ellie Bloom, Special Assistant Attorney General, who on this case and many others are standing up for California consumers, making sure that their rights are defended and protected, and very proud of their work and proud of the work that got us to this point. These individuals and all their colleagues in DOJ's Consumer Protection Section, they work day in and day out to protect and uplift California's consumers. Their work has never been more important because right now we know that California consumers are struggling. They're challenged. From gas to groceries, housing to healthcare, the cost of living only seems to be going up. But as costs go up, life's expenses, they continue. Maybe the fridge broke or the dog ruined the couch. Again, perhaps you just moved into a new place and you need a washer and a dryer ASAP. Many Californians are tempted by rent-to-own agreements offered by businesses like Rent-A-Center, which rent household goods, including furniture and appliances, at extremely high prices. Furnishing a home is expensive, we know that, and consumers often hope these rent-to-own agreements will lessen the cost, not realizing the total price they pay will end up being much higher. Over the years, the rent-to-own industry has been ripe with predatory behavior, often targeting families struggling financially. And today, we're here to resolve the latest violation of our state's strong consumer protection laws. Today, I'm announcing a $15.5 million judgment, including over $13 million in restitution. That's money that will go back into the pockets of consumers, against Rent-A-Center, one of the largest rent-to-own companies in the nation. Rent-A-Center might claim to offer, as they say in their materials, quote, worry-free guarantee, end quote. But our investigation into their conduct found the opposite to be true. Rent-A-Center caused lots of worries and provided too few guarantees. The company violated our state consumer protection laws relating to unlawful leasing practices and deceptive marketing. Specifically, our investigation into Rent-A-Center found that the company's kiosks operating out of traditional retail stores used an inflated cash price for products in its preferred lease program. These products were 15% higher than the retail price, violating California's rent-to-own law. As a result, that couch, that fridge, or that washer potentially cost struggling families hundreds of extra dollars each, money that could have gone to rent, to groceries, childcare, education supplies. And beyond these extra costs, we allege that Rent-A-Center also misled consumers about the most fundamental aspects of their preferred lease products, such as the right to return merchandise at any time with no penalty. As part of today's judgment, Rent-A-Center will implement substantial reforms to its preferred lease business model to deter future misconduct. They will pay $13.5 million in restitution to California consumers, and they will pay $2 million in civil penalties. Specifically, this judgment prohibits Rent-A-Center from charging a cash price markup. Moving forward, the cash price must match the price advertised to the consumer by the retailer. It prohibits Rent-A-Center from preventing or limiting customer returns in any way. If you want to return your merchandise, you may. That's what the Carnet law requires in California. It requires Rent-A-Center to clearly disclose that its preferred lease program is a rental purchase transaction and provide each customer with a Know Your Rights document. In addition, it ensures Rent-A-Center trains their employees regarding California's leading rent-to-own law, the Carnet Act, so they can implement it in real time with California consumers. It requires Rent-A-Center to prepare annual reports for the DOJ, for our office, describing its efforts to comply with the settlement. That's our feedback loop, our accountability going forward. And lastly, as I mentioned, they will pay $15.5 million including $13.5 million in restitution going directly to the pockets of consumers, to tens of thousands of Californians who will benefit for folks who entered into these contracts and were taken advantage of, contracts containing the 15% illegal upcharge. Customers who rented merchandise from Rent-A-Center through its kiosk business are eligible for that $13.5 million available in restitution. Eligible individuals will receive a notice at their last known mailing address. In closing, here's the bottom line. Rent-A-Center repeatedly relied on deceptive tactics to pad its pockets. The company broke the law. And now Rent-A-Center is going to get a taste of its own medicine, paying a steep price for its own bag of goods. As your Attorney General, I won't stand by when a company like Rent-A-Center overcharges hardworking Californians who are struggling, in the process taking money that is needed for rent, for food, for other essential expenses. If a company hurts consumers, if it breaks the law, it will be held accountable. If you see predatory or potentially illegal behavior in the rent-to-own marketplace, please contact my office. We're eager to hear about how we can support your rights and protect consumer rights. You can go to oag.ca.gov/report. We want to hear from you, so please reach out. And because we take reports of misconduct seriously, as today's judgment proves, by not just holding Rent-A-Center accountable, but by providing critical relief to tens of thousands of Californians, and importantly, preventing Rent-A-Center from continuing this conduct in the future. Thank you, and with that, I'd be happy to take any questions.